I'm going to describe trade secrets in non-technical terms using real-world examples or use cases to explain how trade secrets work in practice. Trade secrets protect information which has value from being secret. To understand what is at stake, I ask my business clients the following questions. Would that piece of information be valuable to your competitors? How valuable? How much damage could its exposure cost you? If the client responds yes, then they have trade secrets worth protecting. To protect those trade secrets, they need to show that they have taken reasonable measures to protect the secrecy of the information. The most common way for a company to do this is by ensuring that anyone and everyone who is exposed to trade secrets sign a non-disclosure agreement, or commonly called an NDA. A well-known example of a trade secret is a Coca-Cola recipe. They have managed to keep it secret for well over 100 years. The formula currently is kept in a vault at their headquarters in Atlanta, Georgia. Only 2 anonymous employees know the contents of the recipe at any point in time. In the tech field, a software company's source code is its most valuable trade secret, and disclosure to competitors could cause significant harm to the company. You should think about the value of a trade secret on a spectrum from high to low. Trade secrets such as source code would be highly valuable, while other types of trade secrets, such as product specs to be released next year, would be of lower relative value. Some companies like Apple are known for valuing all their confidential information highly and taking significant measures to maintain the confidentiality of all of their non-public information. What about a client or customer list? Well, it depends. To the extent that the information is neither public nor easy to determine, it is more likely to be held a trade secret. Also, if other non-public information like pricing information is included in the client list, then it is even more likely that it would be considered a trade secret. This is why companies routinely use NDAs, because the definition of confidential information in an NDA is broader than what could be proven in court to be a trade secret. The NDA, if properly structured, can include all information disclosed to the other party, thereby giving the discloser more comfort that the information will be protected and not disclosed. In a future section, we will discuss typical NDAs in detail, with examples of language to use depending on your needs and goals. So how are trade secrets created? There is no need to register or otherwise apply to a federal or state governmental entity to establish your trade secret or to enforce it. Once the trade secret is created, it automatically exists. It is a fragile asset, however, because once made public, it can no longer be a trade secret. The only recourse the owner has is to pursue damages against the party who wrongfully misappropriated the trade secret. As we will see in the patent law section, patents have a limited lifespan of approximately 20 years. Compare that with Coca-Cola's secret recipe, which has been protected for over 100 years. So you can protect an invention as a trade secret. It could be a better option than a patent. Pro tip: use a non-disclosure agreement, or an NDA, internally and externally with your employees, contractors, partners, suppliers, and any third party who has exposure to your trade secrets. If you follow this practice, you will satisfy the legal requirements of trade secret law and will be able to pursue a third party who wrongfully misappropriates your trade secret. Even better, if you have a properly constructed NDA, it will cover all information disclosed, whether or not a court would consider it trade secret. This is why NDAs are so common in Silicon Valley business practices. I am going to describe trademark in non-technical terms using real-world examples or use cases to explain how trademark works in practice. Trademarks affect nearly all businesses, especially those involving the internet, to reach their customers. A more common term is brand. In today's commercial world, branding is key to successful enterprises. As your business grows and becomes successful, your brand is one of your most valuable assets. It is estimated that Google's trademark is worth over $44 billion and comprises over a quarter of the company's total value. Other top marks by dollar value include Microsoft, Walmart, IBM, Vodafone, Bank of America, GE, Apple, Wells Fargo, and AT&T. The American Marketing Association defines a brand as a name, term, design, symbol, or any other feature that identifies one seller's goods or services as distinct from those of other sellers. The legal term for brand is trademark, and its definition is nearly the same: a word, phrase, symbol, and/or design that identifies and distinguishes the source of goods of one party from those of others. A brand or trademark can apply to products or services. The key for legal purposes is identifying the source. Trademark law evolved from unfair competition, where the law aimed to protect the consumer from confusion between merchants' goods or services. Trademark law protects marks, which are considered distinctive. Now, distinctive marks can be classified as fanciful, arbitrary, or suggestive. These three categories are associated with the strength of the mark, where a fanciful mark is the strongest and a suggestive mark is the weakest. Fanciful marks are words that have no common dictionary meaning, such as Kodak or Exxon. These are made-up words where the company invested in marketing its product so that eventually the public would associate its product, like cameras or gasoline, with the mark or brand. The next strongest mark is an arbitrary mark. This is a word that has a meaning in the English language, such as apple, but is used for a different purpose, like computers. Shell for gasoline products is another example of an arbitrary mark. The weakest category of distinctive marks is suggestive. Here the mark suggests, rather than describes, a trait or characteristic of the product or service. Some examples are Greyhound for bus service or legs for pantyhose. Non-distinctive marks include two categories: descriptive and generic. Descriptive marks identify a trait or characteristic of the product or service and are not protectable, at least not initially. Descriptive marks can become protectable through a process called acquired distinctiveness. If you register a descriptive mark, the Trademark Office will list it on something called the Supplemental Register. After 5 years of use, you can apply for the Trademark Office to determine that the mark has acquired distinctiveness and thus is protectable. In contrast, the second category of non-distinctive marks or generic marks are never protectable. To illustrate this distinction, the word ice cream describes a well-known food product and would never be protectable as it's generic. It's a common name for a product. The term cool and creamy ice cream would be considered a descriptive mark because it identifies traits or characteristics of ice cream. It could be possible to obtain acquired distinctiveness over time if the company used the mark cool and creamy ice cream in marketing its product. Examples of well-known products or services which acquire distinctiveness over time include Kentucky Fried Chicken and American Airlines. I am going to describe copyright in non-technical terms using real-world examples or use cases to explain how copyright works in practice. Copyright is intangible property rather than tangible property. Examples of tangible property are your car or house. Your car has a unique identifier called a VIN, which must be state registered. Your house sits on a lot of land, which has been measured and recorded. This book is another example of tangible property. I purchased this one at a bookstore and this one online from Amazon. These books are my property to do with as I choose, well, to some extent. I can resell them at a used bookstore or garage sale or give them away. What I cannot do is copy the book and sell it. or even give away the copy without permission from the copyright owner. If I write a 500-page novel, those 500 pages represent my intangible property, similar in concept to the recorded plat of land or my car with the unique VIN number. It is different because it is possible to make copies of that book or novel with no unique identifier. Copyright law protects the owner from users making copies without the owner's permission. This permission is what we call in legal speak a license. We'll talk more about this in future modules, but it is important to understand the difference between intangible and tangible property. With the advent of personal computers and the internet, it has become much easier for anyone to be a publisher or distributor of electronic books, videos, music, or other digital products. This means licensing is much more important to our economy than it was in the pre-internet era. When is copyright created? The very act of creating something copyrightable, like a novel, is sufficient to create ownership. So at the moment I type the words of my novel, I have created copyright in those pages of the novel. If I believe that a third party has found a copy of my novel and is selling it as their own, I need to go to court to enforce my copyright. In that case, I need to register the copyright in my novel with a copyright office in Washington, D.C. It is very important to emphasize that I do not need to register the copyright to own it. Software companies who have sued third-party infringers, like in the Oracle versus Google case, Oracle did register the copyright because it was a necessary prerequisite to the lawsuit. Many software companies in Silicon Valley have not registered their copyright because they are concerned about revealing trade secrets. I will talk more about this in the trade secrets section, but it is important to know that there are means for redacting the trade secrets when you submit the software code to the Copyright Office. Another reason to consider registering the copyright proactively is that you qualify for statutory penalties and attorney fees against the third-party infringer. Statutory penalties are automatic damages without the need to prove damages in court. If you wait to register the copyright until you learn about the infringement, then you can still recover damages. However, if you want to engage an attorney to bring the lawsuit on a contingency basis, where you do not need to pay them up front, it would be helpful to have the copyright already registered. This is because the attorney is more likely to recoup their fees if the copyright has been registered prior to knowledge of the infringement. I am going to describe patents in non-technical terms using real-world examples or use cases to explain how patents work in practice. Like copyright, patent is another form of intangible property. It protects inventions and dates back to the 1400s in Italy for boat designs and England for glass-making processes. Well-known early U.S. patents include Eli Whitney's cotton gin or the patent granted to Alexander Graham Bell in 1876 for the telephone. These early patents were for mechanical devices related to agriculture, but by the late 19th and 20th century, they were increasingly involving telecommunications and media-related inventions, such as the radio and television. The latter part of the 20th century saw the rise of electronic hardware devices, and by the late 20th century, electronic software devices. It's easiest to understand patents in three parts. First, the patent must meet three requirements: novelty, utility, and non-obviousness. Utility is generally not a high bar. Novelty and non-obviousness are more likely to pose a challenge for the inventor when he or she submits their application to the patent office. Novelty is judged by the prior art, meaning generally has this invention been practiced before. This has been a significant issue for the software field because in the early years of software development, patents were not common. Later, many patents were issued by the patent office without being aware of the existing prior art. Recently, many software patents have been invalidated on these grounds. Non-obviousness is somewhat more nuanced. This doctrine is not in the constitutional mandate for patents and initially was a judge-made doctrine dating back to the 19th century. The idea is to ensure that the invention meets a threshold of inventiveness and would not be obvious to someone practicing in the field. The original 1800s case involved a patent substituting a well-known wood doorknob with a porcelain one. The Supreme Court ruled that there was insufficient inventiveness and the non-obviousness doctrine was born. A recent 2007 Supreme Court case reinvigorated the non-obviousness doctrine and has led to more invalidation of patents by lower courts. Second, a patent must meet the patentable subject matter test. Under this doctrine, laws of nature, natural phenomena, and abstract ideas are not patentable. What does this mean in the real world? It means that certain industries have been impacted. The abstract idea doctrine has generally affected software and internet patents. The 2014 Supreme Court decision Alice Court v. CLS Bank found a computer-implemented electronic escrow service for facilitating financial transactions invalid because it was an abstract idea and not inventive. The decision has led to an increase in invalidation of existing patents by the lower courts, especially those referred to as business method or internet-related patents.